This is an update to an article I wrote regarding the ability for artificial intelligence devices or machines to get patents in their own names without any human beings being designated as inventors. DABUS, short for Device for the Autonomous Bootstrapping of Unified Science, is an artificial intelligence system created by Stephen Thaler, whose purpose is to invent. DABUS created two inventions, a food container and an alert light. Thaler filed patent applications on each in several countries. Thaler claims he didn't direct the machine to invent these products. Instead, DABUS analyzes data, generates ideas, and invents products on its own. Since Thaler wasn't involved in the process of inventing these products, he believes that DABUS should be named as the sole inventor. These applications were refused in the United States, England, Europe, and Australia on the basis that only humans can file for patent protection. Thaler appealed the Australian Patent Office's decision to the Federal District Court of Australia and was successful. The court found that Australian law doesn't require a human inventor, only an inventor. And the judge said that the definition of inventor was ambiguous and did not exclude machines. It's now up to the Australian Patent Office to decide if the inventions are patentable through the normal patent process. Thaler was also successful in getting a patent in South Africa. However, this is less important since South Africa doesn't examine patent applications. Thaler was also refused the ability to file in the United States Patent Office. He appealed this decision to the Virginia Federal Court. He argued that the USPTO's decision was wrong, but the court ruled in favor of the USPTO. The court found that patent law explicitly defines inventors as individuals. Although the Patent Office laws are silent with regard to the definition of an individual, the court said the plain meaning of the term defines individuals as human beings. Therefore, an inventor must be a natural person, a human being. Thaler's arguments were based primarily on policy considerations. He argued that preventing AI to be named as inventor would discourage innovation. And the court responded that policy considerations weren't for courts to decide, they were for Congress to decide. So what's next for Thaler? The next step is to appeal to the Court of Appeals for the Federal Circuit. They're the exclusive court over patent-related appeals. But I suspect that court will decide the same way. The overall takeaway is Congress will have to decide this issue. As I've previously written, Congress is best suited to make these decisions. They can bring in experts, debate, and create patent laws to allow this to happen if it's appropriate. The Virginia court noted that the patent laws were in fact amended as recently as 2011. AI existed when this act became law, and Congress chose not to permit non-humans to be inventors. So you have to ask yourself, maybe Congress has already decided this point. Only humans can file for patents in the United States.